Hearing Erie Court of Appeals, 14 District Texas Trial Session. So if you're going to guys take copies,
You may be seated. Good morning. We are here on cause number 142400993 CR, State of Texas versus Reynaldo Josue Cabeza Torres. Please state your appearances.
Joseph Sanchez for the State of Texas, the appellant.
Ralph Martinez for appellate.
And Mr. Sanchez, would you like to reserve any time for rebuttal?
Yes, Your Honor. 3 minutes.
Let Belinda get ready. You ready? Okay, you must start state.
May it please the court. Good morning, Your Honors. My name is Joseph Sanchez. I'm a prosecutor with the Harris County District Attorney's Office. I represent the state in this appeal. This is an appeal from an order granting habeas relief for ineffective assistance of counsel and involuntary plea without a showing of prejudice. More specifically, there is no evidence of prejudice in this case because there is no evidence that the appellee would have insisted on a trial. The appellee was serving a 3-year deferred for felony retaliation when he filed a writ application under 11072 claiming his plea attorney rendered ineffective assistance of counsel for failing to advise him about the immigration consequences of his plea. The habeas court held a hearing, the plea attorney testified, and the court granted habeas relief and entered findings of fact and conclusions of law, finding that the defendant or the appellee had suffered harm or prejudice. However, there was no evidence to support this prejudice finding, and therefore that was an abuse of discretion by the habeas court.
And why do you think there was no evidence to support prejudice?
Yes, Your Honor. So for there to be prejudice under Hill v. Lockhart, which is a Supreme Court case, the standard is that there has to be 2 sub-elements of prejudice, which is that the appellee would not have pled guilty and he would have insisted on a trial. And since Hill v. Lockhart was decided, the Court of Criminal Appeals has interpreted that case to be a strict pleading standard and to be a strict standard of proof. So people who claim prejudice with regard to involuntary plea can do so through one of several ways. They can either do it directly or they can do it circumstantially. And here, there was no claiming that this appellee would have insisted on a trial, and therefore there was no proof of prejudice.
So where do you cite that? Because what I'm curious about is it your opinion that there's magic words, that there's case law that says you explicitly need the magic words insisted on trial?
Yes, Your Honor. So first in 2016, the CCA decided ex parte Torres. And in Torres, I will say that in Mr. Torres's affidavit, he testified in his writ proceedings via affidavit. He stated that instead of pleading guilty, he would have either sought an immigration neutral plea, or he would have tried to delay his plea in order to seek some sort of relief in immigration court, or he would have alternatively gone to trial. And in Torres, the CCA indicated that this was not adequate proof of prejudice. Then, 1 year later, in ex parte Nelson, which I will say is an unpublished case, however, I cited to it from the CCA because I think it is more factually similar to our case.
Do you have the site?
Yes, Your Honor. Ex parte Nelson is going to be 2017, Westlaw 2462329.
Thank you.
But that same year, they issued Ex parte Aguilar, which is published, and it makes the leap from I would never agreed and entered a guilty plea, et cetera, and then the conclusion of that paragraph is Aguilar has demonstrated that, but for his error, he would not have pleaded guilty and would have insisted on a trial. But from what I can tell from that opinion, he didn't actually say he would have insisted on a trial in the affidavit.
Are you, in his affidavit, he stated he did not say he would have insisted on a trial?
Right. He says, I would never have agreed and entered a guilty plea if I had known except, that it would cause me a problem.
Sure. And so typically in cases like that, the writ applicant has proved up circumstances from which the habeas court can infer that they would have insisted on a trial. And so that is what I mean by a writ applicant can also circumstantially improve that they would have insisted on a trial. And most people in the appellee's position who specifically claim some sort of Padilla circumstance prove up that at the time of their plea, because their immigration consequences were of such a concern to them, that at the time of the writ, they prove that up. And so then the writ court can then infer, well, because their immigration consequences were so important to them, they would have insisted on a trial instead of pleading guilty. But we don't have that. We don't even have that in this case.
So, counsel, you talked about a pleading and proof requirement showing that but for deficient performance, they would have insisted on a trial. So you're saying that even if you proved up the prejudice in a live hearing like you had here, or in affidavits, which are part of this record as well, the fact that they didn't have it specifically lined out in the application or didn't say it as appropriately as we would like means that they're barred from relief?
In so many words, I think that it's not just that they didn't plead it, but they also didn't prove it.
So that's what I want to go to. Okay. This is kind of weird because it's on affidavits and has a live hearing. Tell me the deficiencies as you see it in the affidavit and the testimony, specifically what they missed in testimony and affidavit where they failed to show prejudice such that we could not infer that kind of finding from the trial court's ruling.
Yes, sir. Yes, Your Honor. So first, the direct deficiencies are that they simply didn't plead it or prove it. There is nothing in their pleadings that claim that he would have insisted on a trial.
Stick to the testimony and the hearing and the affidavit. That's going to be your best use of time.
Yes, sir. So in the appellee's affidavit, he does state, and it's a little difficult to understand, but he states, I intend to use my marriage to my wife as a pathway to residency. That he states that in so many words. However, his affidavit was signed and executed over a year after his plea, and he used the present sense of the word intend. Now, if he had said something in his affidavit hypothetically along the lines of, before my plea, I intended to use my marriage as a pathway to citizenship, and I told my attorney about that, then I think the habeas court would have been positioned and the record would have been in such a state that the habeas court could have inferred that he would have insisted on a trial had he known the immigration consequences. But we don't have that.
He says that he would not have pled, he's a permanent resident. What were his options if he didn't plead?
So only he can tell us that. And I think...
But as a prosecutor, what are the options?
Well, if you don't plead guilty, the only other
trial.
options are dismissal of the case or going to trial.
Yes.
However, again, the CCA has indicated that if you just state, I would not have pled guilty, without claiming insistence on a trial, without invoking your right to a trial in your habeas proceedings, there is a lack of substantive harm.
But you do agree that there are no magic words. There's no case law that says you have to put insisted on trial. You can use the inference.
You can use the inference, but I also point to Nelson, which indicates that there has to be some form of insistence on trial.
And
Either
that
the
one's
words
unpublished,
themselves.
right, correct?
Yes.
Okay.
So what was the evidence in Nelson that was contemporaneous with the plea that showed that he would have that they inferred?
Well, in Nelson, Ms. Nelson literally just stated, I would not have pled guilty, period, full stop. She never stated in either her affidavit or in any testimony or even in her pleadings that she would have insisted on a trial, and the Court of Criminal Appeals relied on its Torres opinion from a year before to find that Ms. Nelson had failed to prove prejudice. And by failing to prove or failing to show that she would have insisted on a trial, the CCA indicated that she failed to show substantive harm.
And was the Nelson case a Padilla writ? Only because I haven't read it.
There were Padilla claims raised in the Nelson case. However, I believe it was decided on a different issue. I think it was more along the lines of just involuntary plea for not knowing the state of the evidence or something like that.
So in Nelson, it sounds like there was less in the affidavit than what we have here, and they said that was insufficient. Because we here at least have a relationship with
Correct.
a girlfriend, fiance, whatever it is.
Correct.
So do you have anything that's more, any cases that are more in the middle, like our case?
I was unable to find any in my research, Your Honor. The state's relying on Torres and Nelson combined. But what I will say is that your reference to his relationship with, I guess, his now wife, it's the state's position that even that alone was insufficient for there to be any showing of prejudice, because that evidence did not exist at the time, or at least the record bears out that that evidence did not exist at the time of Mr. Green's representation.
Counsel, remind me, we talked about this last time. Nelson was a writ, and in that case, did the trial court grant relief or did they deny relief?
In Nelson, Your Honor, the trial court granted relief and the Court of Appeals reversed, and the
Okay.
Court of Criminal Appeals affirmed the Court of Appeals.
In Torres, did the trial court grant or deny relief?
In Torres, the trial court denied relief and the Court of Appeals reversed that denial, and then the Court of Criminal Appeals reversed the Court of Appeals.
And so in Torres, the state was having to find deference toward the trial court's ruling. So how do you see that that plays out in this case where we are also deferred to the trial court's findings?
So even with the deference that you have to pay towards the trial court's findings, it's the state's position that this is not a case of insufficient evidence, this is a case of no evidence. And so because there was no evidence of insistence on trial, therefore it was an abuse of discretion for the trial court to find prejudice.
So what kind of facts would you be able to infer that he would have insisted on a trial?
I think what I stated earlier, which is if he had proven in his writ proceedings that his plea attorney was aware of his impending marriage, that he had communicated to his plea attorney that he had intended to use that marriage as a pathway to citizenship, then that would be a sufficient basis from which you could infer that he would have insisted on a trial instead of pleading guilty.
Since we all agree that attorney was deficient and didn't ask him or advise him in immigration, how do we now consider what he told him when we know that the attorney admitted he did not discuss immigration with him?
At the end of the day, in the context of a writ proceeding, it's still his burden of proof to prove both deficiency and prejudice. So it would still be his burden to prove prejudice. So it's on him. It's on him to tell us what he told his attorney and to prove what his attorney was aware of at the time of his representation.
One last question. Can we use the hearing testimony of his attorney as evidence?
You have to defer to the habeas court's findings, and you have to defer to any implied findings with that regard. So independently of that, you cannot use it as evidence. However, the habeas court was well within its discretion to use his plea counsel's testimony as evidence, similar to a jury. Believe some, all, or none.
Thank you, State.
Thank you.
Mr. Martinez?
Thank you, Your Honor. May it please the Honor of the Court. Let me address, if I may, the contention that the magic word argument. First of all, as Justice Boatman pointed out, Aguilar gave relief even though the affidavit that Aguilar filed did not have those magic words, number one. Number two, Padilla itself says there's another way of stating the fact, the standard, and that is, was the rejection of the plea rational under the circumstances? So that gives another way of reading the standard. Padilla itself says that, the U.S. Supreme Court case, Torres echoes that. So there's different ways of stating the standard. There's no magic words. And in any event, we have Aguilar that sustained the court's ruling, and Padilla stated in another way. So my contention would be that by saying I would not have pled guilty, there is no other logical choice than to go to trial. Common sense says that. Only one possible option would be, well, you redo the case and maybe you could structure a plea bargain that's more favorable than what the trial attorney did in this particular case. For example, in this case, if you look at the record, there's a strong argument for this case being nothing but a terrorist threat, not a retaliation. We don't know for sure because the state never produced the DA in the case, never produced the arresting officer, never produced a complaining witness. It relied merely on the testimony by plea counsel, and he was speaking in generalities. There's 3 witnesses, et cetera, et cetera. So there's no really evidence in the record to show the risk assessment and the benefit analysis of the plea offer. The record that the state offered doesn't support that.
Mr. Martinez, I have a question. In the clerk's record, on, I think it may be the supplemental, on page 53, it's the form that is the advice on appeal, and you have to check whether or not you read or write English, speak English. What are your thoughts on that he checked that he did not speak English? Was there a translator?
Well, that would add to the to the appellant's case because the plea counsel didn't speak Spanish, so that would be relevant in determining whether or not he gave the advice. That's the deficiency prong, as well as whether or not he could adequately express his desire to go to trial, if in fact the plea that was structured by trial counsel did not protect him in his immigration.
Were the trial court's admonishments in Spanish or English?
They were, they were in English, but they did have a translator.
Oh, okay.
My understanding is there was a translator. Let me say something further on the prejudice factor. There's 2 things that are really important. One is this counsel wasn't just deficient in terms of, I mean, he completely abandoned his obligation under Padilla.
And we are really focused on prejudice, just to...
I'm sorry?
We're really focused on prejudice. I think the state has conceded that it was deficient.
Okay, I'll address that. First of all, he also gave erroneous advice. That highlights the prejudice. That militates in favor of a prejudice finding, because he said deferred adjudication is not a final conviction for immigration purposes. It is, and this United States versus Musa that I cited, and the statutory record, immigration code says that. So by giving erroneous advice, it enhances the gravity of the deficiency. It becomes very prejudicial. Also,
But I think what we're concerned about is whether you have sufficient evidence that you would have insisted on a trial.
Okay.
And I think that or do you agree that you need to have contemporaneous evidence from the time of the plea? And if so, what, not contemporaneous evidence from the time, but at least about what was going on at that time? Because we have evidence of the meeting that was a year later,
right,
and the marriage that was, you know, whatever it was, like a year later. So what do you have that demonstrates the actual time of the plea?
I would point to 2 things. One was the affidavit of the applicant. I don't know if that addresses your question completely, because, but there's also the record of Mr. Green who testified.
But the affidavit really doesn't talk about, it doesn't give anything from the time. He just says now, you know, it's sort of ex post facto. He's saying, well, I would have insisted on it, or I wouldn't have pleaded guilty, but it seems like that's the risk, because somebody could always say that.
Right, right. No, I understand that. My argument would be that when he met with Mr. Green on at the time, he was showing immigration, a marriage license. He was discussing the immigration intent he had. In fact, Mr. Sanchez, another affidavit, was a witness who was also there, and they were discussing the immigration issues at the time, at least before the plea was taken. And he showed him, look, I just got married, and they were making those discussions before the actual plea, and Mr. Sanchez's affidavit supports that. But I think even Mr. Green also said that he knew he had an immigration lawyer, for example. Mr. Green testified, but I told him, talk to your lawyer, you're on your own advice. Which he didn't, and I asked Mr. Green, did you talk to the lawyer? Did you call the lawyer? Did you find out who he was? And he said no. So he knew he had an immigration lawyer. He knew he was interested in his immigration issues. Did he specifically say it? I don't think it's clear there, but I think it can be inferred.
I don't think they said it either in the record. Where were they for the hearing? Where were the immigration counsel?
The immigration counsel was not called as a witness.
Okay. I have another question for you. One of the things that's the biggest part of Padilla that sticks out in my mind is the Supreme Court says there are some people who would rather go to prison than get deported. And I can certainly accept that, and I understand that.
Yes,
and that's certainly a collateral consequence of a plea. However, there are a broad range of collateral consequences in the world out there. In this case, your client wasn't facing deportation, as I understand it, there's nothing in the record showing that there's been any kind of consequence like that has happened to him. Is it your contention that Padilla covers every single negative outcome that could happen short of deportation in this kind of situation where there's deficient performance?
Let me answer it this way. There has to be clear, specific grounds, immigration consequences. Padilla does require that. In this case, it doesn't have to be deportation. There are case laws where, for example, a person who's deported has discretionary relief, cancellation of deportation. I think that was Duque. But one of those cases where it wasn't deportation, it was the denial of his discretionary relief. In another case, it was a temporary visa that he had, and it wasn't even a permanent resident. So it covers a broad range of issues, perhaps not every issue, because it has to be clear and specific grounds for the immigration consequences do. So in that sense, in this case, I think it's conveyed to the plea counsel what my client, was interested in. And I think the plea counsel was aware of it, but wasn't concerned in pursuing it. And in this case, the grounds, the consequences he has would be, and I put that in the affidavit, he was going to get married with a U.S. citizen. He knew he was at the time that he had just got married before the plea took over, because he showed a marriage certificate to the plea counsel, and it's going to be difficult. It's going to be a hurdle now to obtain that permanent residency.
What do you mean hurdle? Because does that mean it's going to be more difficult but still possible? Does it mean it's an outright bar?
Your Honor, I don't know enough about immigration law. I've consulted people, and it's near impossible.
In your brief, you memo, it cites the Immigration and Nationality Act and states that it has firmly established that a Texas deferred adjudication is a conviction for immigration purposes. And that's in your memo.
Yes.
So how does that apply?
Because immigration, when he applies for his marriage, through his marriage for permanent residency, he has an aggravated felony. Now, an aggravated felony in criminal court is not necessarily an aggravated felony in immigration court. If he had his residency card and he got 10 years deferred, or or less than 10 years deferred, he probably would not be deported if he had his card at the time. Because it's not an aggravated felony as defined by the immigration code. If it was, he's out of here. There's nothing he can do. That's not the case
And does
here.
it matter that it's a conviction?
Yes, because if it's over a year, even if he gets deferred, if it's over a year, it may be considered by him. My belief is it may be considered, but I'm not an immigration expert, but it could be considered the denial of his application through the residency process.
Do we know if he was dating Miss Gonzalez, or dating, or, you know, at the time of the plea? Did he have a relationship with her?
I think the record showed, and you know, it could be wrong, but that he was actually married to her. He showed some marriage certificate, a license to the immigration bureau at his office.
The affidavit says he married her on August 15th, 2023, which was about a year after the plea.
Okay, what he showed the immigration bureau was his intent to get married, the application for the license. They were not married at the time.
Okay, and we have in that record evidence that he showed the application to the plea lawyer at
That's
the
right.
time. Where is that in the record?
I'm sorry?
Where is that in the record?
When Mr. Green testified, he said he opened a file and he showed me some kind of licenses that he had. Mr. Green testified that he had showed him some kind of application or licenses and his inference was that he was getting married or wanted to get his immigration. I think Mr. Green testified to that. But no, he didn't say they were married, and now that you've reminded me, he was not married. As far as the dating relationship, Your Honor, I don't know.
So the underlying retaliation charge had to deal with a domestic violence case, as I recall.
Yes, sir.
And was the complainant in that case the same in the domestic violence situation, connected to the people in the retaliation case? And is that the same person that he is now married to?
No.
Okay.
It's not the same person. Whether they're connected to domestic violence and the retaliation, I think it is connected. But this person he's married to is not that same person.
Okay.
But they are connected with the same person, but it's not, you know, but not this person.
All right, thank you.
And I just wanted to close that in this case, my client could have there was no showing for example, Duque sets out some factors in terms of how you assess prejudice, and it's talked about the risk, the benefits of the plea bargain. No evidence was shown to establish that by the state, but I would contend that if the court sustained the opinion of the trial judge, he doesn't necessarily have to go to trial. We don't know what that evidence really is. Mr. Green alluded to it, but whether it's strong, not strong, we don't know the motives of who the witnesses are, what the circumstances were. But assuming that it is strong evidence, there are other options. For example, it seems to me by reading the record, and I'm not familiar with the case, it could be a terroristic threat. It could be a lesser included offense.
Thank you, Mr. Martinez.
Oh, I'm sorry. Thank you. Excuse me. I just want to thank the court for allowing me argument at this time. Thank you.
You're very welcome, sir.
Mr. Sanchez?
Hey, please, court. I kind of want to pick up where Mr. Martinez left off. So I think it's ironic because he was in the process of talking about how there could be other options to pleading guilty, but that's exactly what Torres claimed in his writ proceedings, and the Court of Criminal Appeals stated that wasn't enough, that claiming I would have done one of these other options, one of which could have been a trial, was not enough to prove prejudice. I think the other thing that Torres shows us is that at the end of the day, in writ proceedings, when a writ applicant claims, I would not have pled guilty, and we all have the question of, well, then what would you have done? Only the writ applicant can tell us what he would have done. And that is highlighted in Torres, because Torres outlined that in his affidavit. Here, the applicant, or the appellee, didn't do that. He didn't show up to his writ hearing to testify. He didn't put that in his affidavit.
And Mr. Sanchez, after hearing from Mr. Martinez, in this case, we know it's deficient and it's actual erroneous evidence. Or erroneous advice. Does erroneous advice from the attorney go towards prejudice?
No, because at the end of the day, prejudice still requires the defendant or the appellee to invoke his right to a trial, and that we don't have any evidence that that would have happened here. I do want to point out, I would like to point you, Justice Boatman, to page 20 of the transcript. In his testimony, plea counsel indicated that he did have a copy of a marriage certificate in his file. However, the face of that certificate shows that it could not have existed at the time of plea counsel's representation because of the date that was on the certificate.
It's the August date.
Yes.
And so we know under Padilla and Aguilera that we're talking about deportation consequences and the prejudice. Here, does it matter if he was trying to get married, since he is not a citizen?
When you say does it matter, you mean does it matter in terms of his confinement, or?
In terms of, is this a deportation consequence? And so you're saying that relying on, and this is, I'm trying to figure out, does it matter whether the attorney knew that he was getting married, if he knew he was not a U.S. citizen? Does it matter?
Yes, Your Honor, because if the attorney at the time of his representation knew, then it would corroborate any kind of inference that he would have insisted on a trial instead of pleading guilty. However, we have no evidence that his attorney knew of that. And then to point out something you asked earlier, I know I'm running out of time, he did initial in the plea paperwork next to the paragraph that states that he speaks English. And then finally, the final thing I will say is that throughout his remarks, Mr. Martinez pointed out that in the writ proceedings, there was no witnesses brought by the state or whatever, but I'll remind the court that in writ proceedings, the state has no burden of proof. So we didn't have to call any witnesses in these proceedings.
So how do you think the admonishments factor into this?
I think that the admonishments go toward, or at least corroborate, the state's argument that that at the time of his plea, had he known of the immigration consequences, he would not have insisted on a trial. Because regardless of whether or not he learned of the immigration consequences from his plea counsel or from the court in the court's admonishments, he was still made aware of them. And at no point did he halt the plea proceedings. At no point did he, say to the judge, oh my gosh, like I can be deported, I could be denied naturalization. Well, my girlfriend is here in the courtroom, let me stop these proceedings and talk to my attorney about how that might, none of that happened. And so that corroborates the state's argument that he wouldn't have insisted on a trial at the time of his plea, quite frankly, because he was not wanting to.
I have one last question.
I have one last question.
So, and just to be clear, from the record in front of us, the immigration consult that happened with these other unnamed attorneys happened pre-plea.
That is my understanding, yes, Your Honor, based on the record.
And then, because I saw this in either the briefs or the writ memo, in the clerk's record, page 46 of the plea papers, it's the admonishments, and it was argued that it is blank, where he would have filled in, this is what my immigration, or what my attorney had advised me regarding
Yes.
immigration.
Yes.
And on the plea papers, he puts nothing.
Yes.
Does that factor in to, would you change your opinion on that he would have been aware if the admonishment papers are also blank?
Yes, Your Honor, just simply because from my experience in this court, the judge typically in their plea colloquy goes through the immigration consequences with every defendant who pleads guilty. However, that is nowhere in the record that it was that judge's that specific judge's habit or practice.
You all good? Thank you so much. State v. Reynaldo Josue Cabeza Torres is submitted, and we are adjourned.
All rise.